now in session. Be seated.
Good afternoon. A brief warning there. We were told they may be testing the fire alarms. So if the fire alarm goes off, just that's testing, and we'll just take a pause till the fire alarm is done, and then we'll pick back up. We probably shouldn't try to do what a former federal judge in Chattanooga did one time when he was new on the bench. His law clerk told me they were doing construction outside the building, and he, brand new federal district judge, he just called the marshal in and tell those people I ordered them to stop road construction. Yes, well, his law clerk said it was true. Until the presiding judge of the Sixth Circuit called and told him we don't usually try to do it that way. All right, call the case, please.
Nicholas Grimaldi versus Ronald Christopher.
We'll hear from the appellant.
Good afternoon, Your Honors. My name is Troy Boland. I represent Dr. Grimaldi, an East Tennessee spine and orthopedic specialist. Your Honors, I'd like to reserve 5 minutes for rebuttal, please.
That'll be fine.
I'm going to limit my arguments to the issues that we seem to hang our appellate brief on. Just a brief lesson in this case. There was an initial motion for summary judgment filed by Morristown Hamlin Hospital. That initial motion for summary judgment was denied by the trial court. That order came down in June of 2017. The court scheduled this matter for trial. As we were progressing toward trial, there were some scheduling deadlines. The defendant, Morristown Hamlin Hospital, filed a second motion for summary judgment. First motion denied, second motion for summary judgment was filed. The defendants, Morristown Hamlin Hospital, raised one additional issue in their second motion for summary judgment. And the trial court highlighted that one additional issue in its 2021 order. That was the order that granted their second motion for summary judgment. And the court, and I quote, says, the hospital additionally now argues that it is authorized pursuant to the medical bylaws to discontinue hospital services pursuant to a section entitled Exceptions to Hearing Rights. The court went on further to say that the court had already decided, that the court found that this was in the first ruling on the motion for summary judgment, that the medical staff bylaws do constitute an enforceable contract. And the court went on to suggest in that 2021 order that Gordon Lentz, who is the acting director of Morristown Hamlin Hospital, did not alone possess the authority to discontinue a program. The new argument to consider that the defendants asked the court to consider was, did subsection F in those bylaws allow these actions to occur? Did it condone them? Did it allow those privileges to be terminated or this spine program to be terminated? Section F of that argument in the bylaws stated as follows. Privileges can be reduced or terminated as a result of the board's decision to close or continue closure of a department of service. In that second order, in the memorandum and opinion order from the trial court, the court relied on that statement in granting Morristown Hamlin Hospital's second motion for summary judgment. The court found that the board had approved the closure of the spine program in which Dr. Grimaldi, keep in mind, Dr. Grimaldi had privileges to perform spine surgeries and all ancillary surgeries dealing with spine up until 2016 when Morristown Hamlin denied his privileges for spine services because they didn't have the program. This goes back to 2014. So it was 2 years later, and then after we'd filed the lawsuit, that his privileges were in fact not granted because they had indicated that they had closed the spine program. the court looked at, in granting the second motion for summary judgment, the court looked at we had a hearing, the court looked at some documents that the defendants had filed after our hearing on the second motion for summary judgment. And what the court looked at was local board minutes from the local board. There's two boards, and if you read through the depositions of Gordon Lynch, the acting director who still is, there were two boards. There was the Covenant Board, and then there were the local board of directors. The charter, when Covenant took over Morristown Hamlin, the charter, as the charter will demonstrate, the local board was soon to be deteriorated. There wouldn't be a local board. The board would have been Covenant Board. And so when the court granted this second motion for summary judgment, the court, in determining that the board had ratified the closure of this program, granted that second motion for summary judgment, and the court states that in its order. It said that the board had approved it and it was authorized to do it. Unfortunately, the court was incorrect in its order simply because the bylaws itself defined what the board was. And this is in paragraph 5 under the definitions that were drafted and created by the Morristown Hamlin Hospital. Board means the board of directors of Covenant Health. Local board means the board of directors of Morristown Hamlin Healthcare System. Limited board means subcommittee, the local board of directors which deals with credentialing matters. Again, the only additional argument was that subsection F, the exceptions to hearing rights that was argued, was that the privileges can be reduced or terminated as a result of the board's decision. That's the bylaws. And the bylaws define what the board is. And that's the board of directors of Covenant Health. The defendants have admitted that the Covenant Board didn't approve this whatsoever, never considered it. It was the local board that considered it in a local meeting and said, okay, based on what Gordon Lynch is telling us, we approve the closure of this program. That's the local board. That wasn't the board. Subsection F goes on to clearly demonstrate, even in subsection F, paragraph 3, it says the medical executive committee shall make a recommendation concerning the formation or elimination of a department or service based upon consideration of its effect on quality and hospital delivery of care in the facility and our community. A medical staff department service can be formed or eliminated only upon the full consideration of the medical staff. That's the doctors that enjoys privileges there. Of the appropriateness of the department and service, elimination or formation. But the board's decision in this regard shall be final. That's the Covenant Board. And the court erroneously...
Counsel, let me boil it down for me. So the gist of your appeal, or the main thing, is whether or not it had to be the, for lack of a term, we'll call it the big board, as opposed to the local board, had to be that board that made the decision to terminate providing those services.
Pursuant to the bylaws, yes, Your Honor.
Pursuant to the bylaws, that's what your appeal rides on.
That's the hinge. And that was the court's only consideration in the second, but that was the only consideration, was that the defendants had raised that in their second motion for summary judgment, it was templated exactly the same as the first, except for this additional argument. And the court highlighted that in its order granting the second motion. They say they raised one additional issue, that the board could approve this, and the board did approve it. But it was the local board that approved it. It was not the board of Covenant Health. The court, when it denied our motion for new trial, highlights in its fourth paragraph, it says, the court notes the plaintiff's theory of the case as laid out in the complaint clearly alleges that the board took an action. That's our complaint. We filed a complaint. We didn't know that there was a local board and a Covenant board until we took the deposition of Gordon Lynch. Again, that is not the court it's trying to pin on us that we label it the board, but the bylaws labeled the board for what it was, and that's the contract that we're relying on that created this contract between Dr. Grimaldi, East Tennessee Spine, and the board. And the court further, in its order denying our motion for new trial, surprisingly, the court says, that for judicial economy reasons, that any further action in this matter is better served at the appellate level. Really don't know what that means, except for it's encouraging that for some reason it's more economical, justified to let this court iron out the differences between these parties when we believe that our one isolated issue and the one isolated issue that the court considered in granting this second motion for summary judgment was, did the board approve it or did the board not approve it? And the definition of the board is simply the covenant board, the big board. And the covenant board did not approve this. There's nothing in the record to demonstrate the covenant board approved this whatsoever. And we're asking this court to reverse and remand that decision to the trial court.
Would it make that much difference then if it was the covenant board, the big board, or the local board? Wasn't there a matter of economics involved there that whoever was the overseer had an obligation to conduct himself in a reasonable manner, not to expend money to maintain a program that was costing the hospital money? They had an obligation to the high board, whether or not the high board had actually approved that, but they had that obligation to do the action until final approval. Is that a question that needs to be considered?
Well, there's no question that there was a process that had it been properly followed, we wouldn't be here today. And I guess doctors are extended privileges based on their application. They asked for certain privileges, and Dr. Grimaldi was granted privileges. The bylaws clearly indicate that if they want to discontinue a program that would impact a privilege, they can do that. Subsection F demonstrates that they can do that, and you don't have a right to a hearing, because if they take away your privileges for some other reason, you're entitled to a hearing. So subsection F says if we take away your privileges because we close a program, we can do that and you're not entitled to a hearing because we closed the program. We don't offer that anymore, so therefore you can't perform those privileges that's been extended. But the process for that is, number one, notify the doctor that we're closing this program, we're terminating this program, reissue their new privileges, right? Taking away those others, but also you got to have the board's approval, the big board. And you've got to discuss that community involvement, you've got to discuss those economic reasons, and you've got to actually close the program down. Gordon Lynch in his deposition testified they still had the spine bed, it was still on site, they had the employee and personnel. So basically what Covenant Health did in a nutshell was they took away these privileges by saying they had closed a program in which they hadn't closed the program.
But is there any evidence in the record that anybody else was performing this specialized surgery after Dr. Grimaldi stopped?
I can't remember if Dr. Grimaldi testified as if there was anyone else performing spine surgeries or not. There were other surgeries, not just specialty spine services, and I believe those were being performed.
And he could have performed other services there, just not the services that required the specialized bed and the staff?
I don't know.
Okay.
Some of the services did require the bed, which was on site, and Gordon Lynch testified that it was on site, but there were other services dealing with the spine that didn't require the bed that he was not able to perform. Thank you.
You have your time for rebuttal. We'll hear from the appellee.
Good afternoon, Your Honors.
Afternoon.
My name is Dan Ray. I'm counsel for Covenant Health. Gordon Lynch, the Chief Administrative Officer of Morristown-Hamblin Hospital and Morristown-Hamblin Hospital. Actually, it's Morristown-Hamblin Hospital Association. Mr. Cowan is counsel for Dr. Christopher. The plaintiff's original lawsuit raised separate claims against Dr. Christopher. Mr. Cowan basically adopted our statement of facts in his brief and has authorized me to speak in his behalf to the extent we need to. And so this is not going to be a divided argument.
All right, thank you.
We want to make one point to begin with, Your Honor. There was more to the motion for summary judgment than just the what we would call the termination by closure clause. The bylaws did contain, the medical staff bylaws did contain a clause that specifically said privileges can be reduced or terminated as a result of the board's decision to close or continue closure of a department service. The evidence is undisputed. In fact, it's admitted by plaintiff in the record again and again that no other physician besides Dr. Grimaldi was operating, doing these specialized spine surgeries. Now, what the court should ask is, what do you mean by specialized spine surgeries? Again, there's no question in this record, because Gordon Lynch testified to it repeatedly without contradiction from Dr. Grimaldi at any point, that the specialty spine surgery involved the implantation of hospital-purchased spinal implant materials, hardware and materials, into Dr. Grimaldi's patients. Dr. Grimaldi was the only physician at Morristown Hamlin Hospital, then or now, doing that kind of surgery, that kind of specialized surgery.
Mr. Ray, but what was the basis for the trial court's grant of summary judgment?
The basis for the trial court's grant for summary judgment, he had two. First, the judge decided that the case was ripe for summary judgment, meaning that any issues of a genuinely disputed fact had been resolved by the evidence that was introduced with the second motion for summary judgment. Some of that evidence included the deposition of Dr. Grimaldi, which was not included in the first motion. And that cleared up any issues of disputed fact that came up in the hearing on the first motion. So we had that, plus we had the termination by closure clause that I've just read. But there's another clause in the contract that justifies the court's finding that the issue is ripe for summary judgment because it only involves an issue of law, not an issue of fact.
All right, but do you agree or disagree that the basis for the trial court's termination was that clause in there that said the board could terminate?
Yes,
okay.
And what the court ruled, I'm trying to answer your question, Your Honor, I'm sorry.
That's fine, go ahead.
What the court ruled is that Gordon Lynch, as the administrator of the hospital, could not make that decision on his own the way that one particular clause read. That's all the court considered. We don't agree with the court's conclusion or his reasoning that, well, the facts are that maybe the board did decide it, but maybe it was the local board. We don't agree with that line of reasoning or that is really a genuine issue of material fact. The question of material fact, or the question of law before the court under his appeal, is whether or not Gordon Lynch had the authority to invoke this termination by closure clause as a means to close the program of spinal implant surgery. And we believe the bylaws are clear.
But that wasn't the basis for the trial court's decision.
No, it's not the basis for the trial court's decision. That's correct. We don't agree with the trial court's reasoning that
it had to be the board.
Yeah, that it had to be the board making its own formal decision. We don't agree with that reasoning, but that was the court's reasoning.
Let's talk about that just first.
Okay.
Why was the trial court wrong in saying?
Because the court didn't read the entire contract. You have to construe all of these clauses in the context of all of the other clauses. And there's another clause in the contract, in the record of this case, in the bylaws, in the record of this case, that makes it clear, we believe, that Gordon Lentz, as the agent of the board, had full authority to make that decision to close the program in the board's behalf. That clause is the definition of the word administrator in the bylaws. It's in the technical record, volume 4, page 414, paragraph 2 on that page. And that clause reads, administrator means the hospital administrator or chief administrative officer, CAO, regularly employed by the Covenant Health Board to act on its behalf in the overall management of the hospital. That's what Mr. Lentz was doing.
All right, so is it your argument that when Mr. Lynch made that decision, acting on behalf of the board, that was the equivalent to the board's action?
Yes.
All right.
And that's supported by all kinds of legal authorities defining the law of agency. If the court wants me to, I can cite a couple of cases, a couple of authorities, or I can submit that in a later letter. But the law of agency, all the principles surrounding the law of agency basically say that the act of the agent is equivalent to the act of the principal. And that's just basic agency common sense. And Judge McClarty is right. Gordon Lentz made this decision on his own in order to save the hospital $1 million or so a year that Dr. Grimaldi's program was costing the hospital because of the expense of the hospital having to purchase new spinal implant hardware and materials for each surgery. Because once they're in the patient, they're gone. The hospital had to keep buying that stuff if this program was going to continue. Dr. Grimaldi has no privilege to require the hospital to do that. That's a business decision by the administration, by the board of Covenant Health Board, but under the laws of agency and under the definition of the administrator in the bylaws, the administrator is the agent of the board.
Of the Covenant Board,
Of the Covenant
not
Board.
of the local board.
Correct. It says regularly employed by the Covenant Health Board to act on its behalf in the overall management of the hospital. And saving money from wasteful expenses is definitely within the overall management of the hospital. So basically, this was the board's decision that was made in its behalf by Gordon Lentz. That's our basic argument. This argument was raised in Mr. Cowan's good brief, and it's raised in response to Mr. Bowen telling the court that, well, the backup argument that Mr. Lentz was the agent, that's not in the record. Well, it is in the record. The definition of administrator puts it directly in the record of Mr. Lentz acting as the agent in behalf of the Covenant Health Board to manage this hospital's bottom line, which was losing money because of Dr. Grimaldi's practices.
All right, so am I correct, and tell me if I'm wrong, that it's your position, your client's position, that the trial court got it right but for the wrong reason?
Yes.
Okay.
Yes. One thing the court did get right, we want to emphasize that. The court did conclude in its summary judgment order that the only issue remaining in the case was an issue of law for the court to decide, not a jury. And when the court ruled on the motion to alter or amend, the court amplified that, says it's just a waste of money for me to decide this issue of law. It's very simple for a court of appeals to decide, who are equally qualified to decide issues of law arising from this contract and from this law of agency that's out there. The court was correct in that. This issue was ripe for summary judgment. There is no genuine issue of material fact with respect to the application of the termination by closure clause and with respect to Gordon Lentz's position, certified in the bylaws themselves, that he was the agent acting in behalf of the Covenant Health Board of Directors in the overall management of this hospital. That is our position. The judge is right. This case is ripe for summary judgment. There's no reason to send it back. If Your Honor wants to see the entire contract, it appears in the record about 8 or 9 times. That's why there's 2 boxes over there. This is the entire contract. But the court only needs to look at 2 clauses in that contract to resolve this issue of law. The 2 clauses in the contract are the termination by closure clause and the administrator clause. In the definition of administrator, it appoints Mr. Lentz as the agent for the Covenant Health Board in the overall management of this hospital. I'll be happy to try to answer any other questions the court may have.
I hear none. Thank you. We'll hear from appellant in rebuttal, please.
Thank you, Your Honor. Just a couple of highlights. Dr. Grimaldi's privileges remained the same up until September the 30th of 2016. They kept extending these privileges to him. If the program would have been closed, why extend the privileges? It's because Gordon Lentz did not have the authority to close a program.
The privilege, are you talking about actual privilege to see patients at the hospital or privilege to perform that particular procedure at the hospital?
Anything related to spine, whether seeing a patient or performing surgery, he was not allowed to do at the hospital, even though he had privileges. If the hospital doesn't have the equipment, the tools to provide services, they don't extend the privileges.
Okay, so he could not do that particular procedure at the hospital?
Anything related to spine. I don't want to say that particular procedure because there were several procedures, is my understanding, that Dr. Grimaldi was utilizing. He was recruited for this. He was uprooted from New York to come to Morristown Hamlin Hospital to perform these specialized services.
But during the time that he was not there at the hospital, when he withdrew from the hospital and performed his services for another entity, at that time, did the hospital continue to have to carry on some form of a staff to provide those services, although they weren't performing? What's in the record? I'm only asking for what's in the record.
Well, what's in the record is they didn't terminate anybody, they didn't fire anybody, they were there. The nurses, we're talking about staff, the nurses were there. They may have shifted them around to different areas within the hospital, and they weren't designated on a special day to be in the operating room or the OR room, Dr. Grimaldi, but they surely didn't lay them off because they chose to close this program. You know, Dr. Grimaldi chose to utilize it. The trial court, we filed a motion to compel because we were given a cherry-picked amount of data from Morristown Hamlin Hospital trying to suggest why this was costing them money. Dr. Grimaldi spent time with the CEO of Morristown Hamlin Hospital telling him why his data was wrong. In other words, they were billing for a particular service, and it was actually another service which required more implements and different things. It was a billing issue on some of those cases. So we asked the court, we need the raw data. We need the data to see if this is costing money, because the bylaws are clear that membership shall not be granted or denied based solely or primarily on economic criteria.
But they can close a program based on economic criteria.
If the board approves it, that's correct. That's absolutely correct. So even if you take the defendant's argument today that Gordon Lentz, acting as CEO alone, could close this, the trial court ruled in its court finds that the hospital's argument, Gordon Lentz acting alone as CAO, closed the program for section be unpersuasive. Because they made that argument in the very first motion for summary judgment, and the court
But
denied
what
it.
they did, I'm trying to remember, what they then did was supplemented with the minutes from the board meeting.
What had happened was we had our, I think it was a Zoom hearing, as a matter of fact, on our second motion for summary judgment. I may be wrong, but I think I'm correct. And Gordon Lynch was available. And I think it's in the, I think there's a transcript of that. And the court asked if anybody had approved this, because that was what the court was hanging its hat on, was this newly raised issue, only issue, newly raised issue in their second motion. And I believe that Gordon Lynch indicated that there were maybe 2 or 3 local board members he'd discussed this with. Then after that hearing, the defendants go and send these minutes in, redacted versions. I don't know what they are, except for they have names on them. And I objected to that, because that was after I wasn't provided those, so I objected, and I objected in our motion for new trial. But nonetheless, it still indicated that the local board seemed to have considered something, but that was not the Board of Covenant Health.
That was the small board, not the big board.
The small board, not the big board. And if you even take their arguments, the bylaws are in conflict with one another. If you take the argument that Gordon Lynch can suspend his program, well, that totally contradicts what subsection F says, where he's entitled to a hearing. There's no question in my mind that they could have suspended or terminated Dr. Grimaldi's privileges by closing that program, and he wouldn't have been entitled to a hearing. But to do it by any, if the board approved it, but by doing it by any other means, he's entitled to a hearing.
Well, what specific, and I know your time's up, but go ahead. That's fine, don't worry about it. What specifically do you say to their argument that they made today and made before the trial court, that this was the agent of the Covenant Board? That the bylaws give him the authority to act as the agent of the board, what does it say? Act on its behalf in the overall management of the hospital, so that when he made this decision, he made it as the agent of Covenant Board. I know that's not what the trial court based it on, but what do you say to that argument?
I don't know what management is. I know that privileges are extended by the medical executive committee.
I understand, but he continued to have, your client continued to have privileges.
Correct.
Continued to have privileges to perform surgeries.
Well, privileges that they were not allowing him access to the tools.
I understand he couldn't perform those kind where he needed a special spinal bed, but did he have privilege to perform surgeries?
He did.
Okay, so they didn't, okay. But what, again, what do you say to their argument that the agent's actions, this guy was designated, as the administrator was designated as the agent of the Covenant Health Board to act on his behalf in the overall management of the hospital. So when he made the decision, that was the decision of the Covenant Board.
I have 2 responses to that. My first response is they raised that argument in their first motion for summary judgment that was denied. And if they had chose to appeal that decision, they very well could have, because it was denied.
Well, they could still appeal it. That wasn't a final judgment.
But that was not a final judgment unless we went to trial. But be as it may, the notion that Gordon Lynch, acting alone, could close a program conflicts with what the bylaws suggest. The bylaws state that it has to be a result of the board's decision to close or continue the closure of a program.
As a practical matter, though, I mean, let's assume that we go with your argument and say that it had to be the decision of the board. And Mr. Lentz went ahead and did this. Presumably, if this decision was against the will of the board, they could have come back and said, no, that was not our decision. Or likewise, they could have gone back and, I mean, nothing happened. So obviously, that's what the board intended to happen.
Well, Your Honor, with all due respect, I can assume that. I don't know that. I don't know if they were ever on notice. I mean,
Yeah, this is just me sort of trying to be practical, but not necessarily in the record.
And the Covenant Board is scattered everywhere. They're not just here locally in Knoxville, and they're not in Morristown. They may have a member or 2 of that, of members of, Morristown Hamlin Hospital. The Covenant Board, in the appropriate way pursuant to the bylaws, would have been to close the program with the board's approval in 2014. You can't continue to extend, the bylaws does not allow you to continue to extend privileges for a doctor to perform his services while you have the tools, and Gordon Lentz testified to this in his deposition, everything was still there. And they continued to extend privileges all the way up until 2016. And whether or not, I get where I was going earlier, whether or not this was, if it was costing them money, unfortunately, due to these motions for summary judgments, we were never, there's probably a handful of motions to compel still to consider, because we had asked that the data be given to us, because they were in control, and it's in Gordon Lentz's deposition, they were in control of negotiating the prices for the implements and these type things. We asked for that data, and it was denied up until the court considered the motion for summary judgment. So to assume, I mean, this is not our motion, and I think it should weigh in favor of the plaintiff, to assume that the hospital was losing $1 million a year, there's nothing in the record to suggest that.
Thank you. Court's thanks to... No. Our thanks to counsel for both sides. We appreciate your oral argument today and your briefs. It was a good try, though.